Assalamualaikum and a very good morning to Dr. Ratna. I represent Group 2 for the title The Law of Treaties. Our group had chosen 3 cases on this topic. I, myself Nur Azrin binti Muhammad Zaini with metric number 270374 had chosen the case of the applications of the Convention and the preventions and punishments of the crimes of genocide, which is in between Bosnia and Herzegovina and also Serbia and Montenegro. Meanwhile, my 2 other friends, where Nur Shahira binti Rusri Fazil had represent their case on fisheries jurisdictions, which is in between UK and also Iceland, while Wigati Bagdavi Goran had chosen the case of concerning territorial and the maritime dispute, which is in between Nicaragua and also Colombia. Okay, let's start with our first case, which is fisheries jurisdictions, followed by issues on territory and maritime dispute, and last might be presenting by me, which is about issues of the crimes of genocide. Now, I would like to pass to Nur Shahira to represent her issues. Thank you.
Assalamualaikum. I will explain about fisheries jurisdiction United Kingdom versus Iceland. According to the Treaty 1961, Iceland has been given 12 nautical miles of its coastline for exclusive fisheries. The United Kingdom ratified this treaty on the grounds that any fishery dispute regarding fishing jurisdiction outside this zone must be settled by the ICJ. July 17, 1971, Iceland stated that they do not recognize the Treaty of 1961. Their aim was to increase their nautical jurisdiction from 12 miles to 50 miles. On April 14, 1972, the United Kingdom brought the case forward to the ICJ. This was based on the 1961 agreement that any fisheries concern regarding any fisheries jurisdiction must be settled by the ICJ. Immediately after the United Kingdom brought the case forward to the ICJ passed a temporary protocol of protection until the case had been settled. Iceland states that because there has been a change in the circumstances of international law, that the Treaty 1961 does not apply. Iceland claimed that the reason of their extension of 12 miles nautical because differently of fish stock. Later, the UK responded there has not been a radical change of circumstances within international law. Thus, Iceland has no justification in breaking the Treaty of 1961. The UK also said that there was no legal framework in place that permits Iceland to extend their fishery jurisdiction to 50 miles nautical miles, and the UK shed their doubt on Iceland's claim on the depleting in fish stock. That's because Iceland cannot legally exclude UK fishing ships outside of their 12 nautical miles. The UK said that in order to Iceland to legally expand their exclusive fishing zone, the reason of expansion must be examined in good faith by both countries. The court decided that Iceland and the UK had to undertake negotiation in good faith to find equitable solution to their different concerning respective fishery right. The parties were to consider that Iceland was entitled to a pre-fisher share in the distribution of fishing resources due to the special dependence of its people open coastal fisheries, as well as the principle that each state must pay due regard to the interests of the other in the conservation and equitable exploitation of these resources. The court noted 2 concepts that had been accepted as part of customary law. First, the idea of fishery zone in which each state may claim exclusive fishery jurisdiction independently of its territorial sea, and that a fishery zone up to a 12-mile limit from the baseline is generally accepted. The second one is the concept of preferential rights of fishing in adjacent waters in favor of coastal state which has special dependent on its coastal fisheries. Additionally, they ruled that the change in circumstances within international law were not radical enough to justify Iceland's claims to a larger exclusive fishery zone, and the Treaty of 1961 was to be upheld. And
Assalamualaikum warahmatullahi wabarakatuh. My name is Wigati Bagdavi Goran and my metric number is 260490. Now I want to talk about the concerning the territorial and maritime dispute Nicaragua versus Colombia. On 6 December 2001, the Republic of Nicaragua documented an application organizing procedures against the Republic of Colombia in regards of a debate concerning a gathering of related legitimate issues remaining alive between the two states concerning title to an area and oceanic delimitation. On 13 December 2007, the court said that they found that it had purview to engage the question concerning sway over the oceanic highlights guaranteed by the parties, other than the island of San Andres, Providencia, and Santa Catalina. The court couldn't have word over it under the American Treaty on Pacific Settlement, otherwise called the Pact of Bogota, and summoned by Nicaragua as a reason for the court's purview for the situation. The court presumed that the 1928 treaty had not affected an overall delimitation of the sea zones among Colombia and Nicaragua, and that the debate had not been settled inside the importance of the Pact of Bogota. Its judgment delivered on the benefits of the case on 19 November 2012. The court tracked down that the regional question between the parties concerned power over the highlight range in the Caribbean Sea, which were all above water at elevate tide and which were thusly islands equipped by
Okay, back to me again, where I will focus on my case, which is Bosnia-Herzegovina and also Serbia-Montenegro. Basically, the overview of this case is about international armed conflict that took place in Bosnia-Herzegovina in 1992 until 1995. It can be said that this conflict was lasted for 4 years between Muslim Bosnia ethnic groups, the Orthodox Christians Serbia ethnic group, and the Catholic Christian Croatia ethnic groups when they want to achieve independence on 29 December 1992. However, the referendum to achieve independence was rejected by Serbia delegation under leadership of Radovan Karadzic as a measure to control Serbian territory and also create their new republic. In addition to controlling the territory and create their new republic, they also carried out ethnic cleansing of Bosnia and Croatia. This ethnic cleansing, or more commonly known as a genocide, has resulted in the death of 1.1 million of Bosnia and Croatia in the conflict. So that is the basically main overview of this case. Okay, let's move on to the final court decisions and also the principle of law in this case. Due to severe dispute, it can be said that this case was taken to the International Court of Justice in The Hague, Netherlands. According to the ICJ website, it stated that Serbia was guilty of the killing themselves. In fact, coupled with court tribunals that sentenced 74 Serbia. So that is basically the final decision that had been made by International Court of Justice. Meanwhile, the principle of law in this case that can be found is after the War of Bosnia-Herzegovina, where the Bosnia-Herzegovina established aim at regulating the acquisition, transmission, and loss of Bosnia and Herzegovina citizenship. I think that the framework of law that I can say here is that is based on the principle of jus sanguinis. Jus sanguinis refers to the legal principles of citizenship by which citizenship is determined or acquired by the citizenships or ethnicity of one or both parents. I think that's all from me regarding my point and my friend's point. Thank you, doctor. Have a nice day and Assalamualaikum.